Member for King.
Mr Deputy Speaker, I rise to support the Statutes Amendment Child Sexual Abuse Bill 2021, another example of the important work led by the Attorney-General, the member for Bragg. I am so pleased to be a member of the Marshall Liberal Government implementing the recommended changes to create a safer South Australia and provide justice for children and survivors. The Royal Commission into Institutional Responses to Child Sexual Abuse released its Criminal Justice Report in August 2017. This bill delivers action, not talk. It delivers real changes to legislation to deliver on incredibly important recommendations. The report makes 85 recommendations aimed at addressing or alleviating the impact of past and future child sexual abuse and related matters in institutional contexts. A number of the recommendations of the report require legislative reform to be implemented and are addressed in the Statutes Amendment Child Sexual Abuse 2020. The principal reforms are defence to position of authority of offences. The Criminal Law Consolidation Act 1935 contains several specific sex-related offences where the defendant is in a position of authority in relation to the child. These offences were created in recognition of the higher standard expected of persons who are in a position of authority and the extra vulnerability of a child in that situation. The category of persons who are in a position of authority includes a person who provides religious, sporting, musical or other instructions, which could include young adults who are in similar age to the alleged victim. Failure to report offence, Clause 7 of the bill, implements Recommendation 33 to create the offence of failure to report child sexual abuse by employers of institutions that operate facilities or provide services to children who are in their care or under their supervision or control, including medical and religious institutions. Employees of such institutions are in positions of trust with children and have a duty of care to prevent their sexual abuse. Failure to protect offence, Clause 7 of the bill, implements Recommendation 36 to create an offence of failing to protect a child from sexual abuse in institutions that operate facilities and provide services to children who are in their care or under their supervision and control, including medical and religious institutions. The offence emphasises the obligation of responsible people to prevent child sexual abuse, not just to report it once it has occurred. Presumption of males under the age of 14. In 1976, the Criminal Law Consolidation Act 1935 was amended to abolish the presumption that a boy under the age of 14 is incapable of having sexual intercourse. Clause 8 of the bill implements Recommendation 83 to make this presumption retrospective so that perpetrators of historical sexual offences cannot be protected from being charged and convicted due to the presumption. Pre-recorded evidence recommendations 52, 53, 54, 56 and 60 propose pre-recording of evidence by child sexual abuse victims in order to alleviate the need for these victims to attend court where they are again confronted by their abuser and often experience significant distress during cross-examination. Provisions of the Evidence Act 1929 and other related legislation already allow for pre-recording of victims' evidence at various stages before and during trial. The proposed reform seeks to expand those provisions. Investigative interviews, Clause 20 of the bill, implements Recommendation 52A by amending the Summary Offences Act 1953 to require recording of investigative interviews with police of all 3 child sexual offence victims, no matter what their age is at trial. Application can be made under the Evidence Act 1929 for these recorded interviews to be admitted at trial instead of the witness having to give evidence. Pre-trial special hearings allow witnesses to give evidence before trial without the defendant present. Such hearings are currently only available under Section 12AB of the Evidence Act 1929 for children under the age of 14, or where the witness suffers from a disability that affects the person's capacity to give a coherent account of experiences or respond rationally to questions. In line with recommendations 52 and 53, Clause 11 of the bill amends the Evidence Act 1929 to expand categories of witnesses who may have pre-trial special hearings to include the following: all victims of child sexual offences, no matter what their age at the time of trial, and any other witnesses who is a child or is vulnerable who is to give evidence in a child offence matter. Application would be made for the court to decide whether they should come within these provisions. It has also proposed that these pre-trial special hearings be available for domestic violence victims. Audio-visual hearings. Clause 13 of the bill implements Recommendation 56 to amend the Evidence Act 1929 to require audio-visual recordings of the evidence of all victims of child sexual offences. Juvenile offenders. Clause 21 of the bill implements Recommendation 84 to amend the Young Offenders Act 1993 to provide that for the purposes of a preliminary examination at committal proceedings in the youth court, pre-recorded evidence of a victim of a child of sexual offence given in another court or during the investigative interview can be admitted. Provide that child sexual offence victim cannot be required to give oral evidence at a preliminary examination during committal proceedings in the youth court. Expert evidence on the children. Clause 14 of the bill amends the Evidence Act 1929 to implement Recommendation 69 to allow expert evidence in relation to the development and behaviour of children generally, and those children who have been victims of child sexual abuse to be admissible in proceedings relating to sexual abuse of a child. Such evidence would be useful to the judge and jury to better understand evidence given by children. Propensity or similarity of account evidence. Recommendations 44, 45, 49, 50 and 51 propose reform to the test for admissibility of tendency and coincident evidence to increase the admissibility of this evidence in child sexual abuse matters. Religious confessions. Clause 16 of the bill implements Recommendation 36 and the intent of the principles endorsed by the Council of Attorney-Generals to provide that the fact that information was gained during or in connection with a religious confession does not prevent that evidence being given or disclosed in civil or criminal proceedings. Sentencing for multiple offences. Clause 17 of the bill amends the Sentencing Act 2017 to implement Recommendation 75 to require the court, when setting a sentence in relation to offences involving multiple discrete episodes of offending or where there are multiple victims, to indicate the sentence that would have been imposed for each offence had several separate sentences been imposed. This reform ensures that recognition is given to separate episodes of offending in sentencing. Sentencing standard for offences involving child sexual abuse. Clause 19 of the bill implements Recommendation 76 to amend the Sentencing Act 2017 to make it clear that in sentencing for child sexual offences, sentences must be set in accordance with the sentencing standards at the time of the sentencing instead of at the time of offending. As I've said in this place before, we must do all we can to work together to stop child sexual abuse. The statistics say it all. 1 in 5 children will be sexually abused in Australia. This is utterly unacceptable. It is appalling that I've needed to sit here and listen to Labor choose to play politics on this topic, which our community expect us to work together on. This is a no-brainer. There's no reason to play games with safety. I'm keen to get on with this and other changes as soon as we can so that more South Australian children can grow up safely. I commend the member for Bragg for her relentless hard work leading the implementation of these legislative changes to hold perpetrators of all types of abuse to account, to increase the harshness of consequences for those who sexually abuse children, and to help victims to be better protected while giving evidence and to seek justice. And I commend this bill to the House and thank the Acting Attorney-General for taking carriage of this bill.